changes here. So I would like to introduce the next panel. The panel is the session is on latest trends in infrastructure contracts. And the session is being moderated by our partner, Mr. Abhimeet Sinha. And Abhimeet has been instrumental in establishing our firm's forte in government advisory, infrastructure, renewable energy, and electricity sector. He has been commended by the clients for his sharp legal acumen, calm and composed nature, and a good business sense. Abhimeet has been legal advisor in prestigious infrastructure projects. A lot of them are classified projects of Government of India. These projects are of vast social and public importance. Some of the famous infrastructure projects where he has been the legal advisor is Omkareshwar Dam, which is amongst the largest floating solar power projects of India, Delhi-Mumbai Expressway, and Ro-Ro Ferry in Gujarat Maritime Board. Thank you. Please. Okay. Our next panelist is Mr. Vikas Kumar Sinha. He's General Manager Law and is from Indian Railway Administrative Services. Mr. Sinha has nearly 2 decades of legal experience, and most of it is with Northern Railways. Currently, he is working with DFCCIIL, Dedicated Freight Corridor Corporation of India Limited. Mr. Sinha has led legal information and briefing management system development for Northern Railways, and now this has been implemented nationwide by Ministry of Law for briefing management system of all the court cases. Not only this, he has also led the RTI portal, the process of automation of RTI applications with Indian Railways. Now it is a completely paperless process. Mr. Sinha has experienced in public finance, crisis management, contract disputes, service matters, consumer cases, and land acquisition. Our third panelist is Mr. Akshay Gupta. He's from Kotak Mahindra Bank. He's an executive director at Kotak Mahindra and is an alumni of XLRI Jamshedpur. It is a pleasure to share with you that he's listed among India's top 40 under 40 in alternative investment professionals in India. He was part of the team that set up the infrastructure fund at Kotak Alternate Assets, and he has made multiple investments in sectors such as road, concession, power generation, and energy storage. He has also helped in implementing ESG principles, which is environment, social, and governance principles across different investment, and is also a member of Indian Venture and Alternate Capital Association. Last but not the least, our third panelist is Mr. Harsh Singhal. Okay. Yeah, he's the co-founder of Building and a Financial Services Startup. With over 2 decades of experience, he has served as the Managing Director India for CDPQ, which is Quebec, which is the Government of Canada's public and para-public pension plans and insurance program. Amongst his many achievements, one has been he initiated the concept of tax exemption to sovereign wealth funds and provident funds with Government of India. He prepared economic case for Government of India and worked with regulatory and industry authorities for smooth implementation of exemptions. So regular feedback and follow-ups do help me. This exemption helped enhance returns on infrastructure investments in India besides reducing tax compliances. Mr. Singhal has also experience of working with McKinsey, SRF Limited, PwC, Boston Consulting Group, and International Finance Corporation. Over to you, Abhimeet. Thank you.
Hello everyone and good afternoon. Today we are now at the last session. Sequentially, this should have been the first, as there is a contract, then there is arbitration, and then there is expert evidence. But insofar as the topic is concerned, there is so much excitement among the stakeholders with National Infrastructure Pipeline, which advocates a massive 102 lakh crore investment in infrastructure. This is quite different from what Mr. Rakesh Mohan Committee in 1995 provided for road sector, which was mere 30,000 crore for a period of 5 years from 97 to 2002. Insofar as the contractual arrangement for infrastructure projects is concerned, it all depends upon the role of entities involved and the allocation of risk between them, and also the funding, which entity is taking the load of the funding. It is generally understood if the public entity is involved, it is a EPC contract, and if there is a participation of a private entity, then it's a public-private partnership model. There are so many prevalent models nowadays. To start with, BOT toll, BOT annuity, HAM, recently TOT, and a combination of any of these, which now the government is advocating. Insofar as latest trend is concerned in the contracts, all the stakeholders in different sectors have coordinated for suggesting amendments in the Model Concession Agreement. Insofar, briefly, I will just sum up some of the latest amendments or the suggestions in the Model Concession Agreement. For highways, now the mutual foreclosure of the contract has been allowed. There used to be so many delays in start of the project because of the land acquisition issues. Now it has been decided and incorporated in the contract itself that only after 90% of the land is ready, then only the award of the project can be made. In the ports, there has been a new major ports authority bill. The tariff authority of major ports has been done away with, and some of the recent changes with the latest MCA has been, insofar as major ports is concerned, that if because of change in law, concessionaire is unable to handle the cargo for which he entered in the concession agreement, the parties can discuss, deliberate, and then after the discussion, the concessioning authority can allow a new cargo to be handled or extension of the concession period. One of the major thing has been, after having done away with the TAMP, that is Tariff Authority for Major Port, now the concessionaire is allowed to fix tariff as per the market condition. Like HAM concession agreement and TOT concession agreement, in the concession agreement for major ports, after the termination, if the termination happens prior to the COD, the concessionaire can get the compensation. Latest PPA on finance own operate model is being drafted, with which we are also involved. The change in law provisions, which used to be a topic of concern, has been linked with the change in law regulation issued by CERC. Similar has been the case with the payment security mechanism. That also has been linked by a regulation issued by CERC, that is late payment surcharge regulation. We have discussed the national infrastructure pipeline with a massive investment. We have discussed now what kind of changes have been brought in the major concession, in the concession agreements. All this can fructify only there is an able, sufficient financing mechanism with modern, innovative financing structure to finance all these projects. There has also been a National Bank for Financing and Infrastructure Development. There also recently, a few days back, Infrastructure Finance Secretariat has been set up. Both National Bank for Financing Infrastructure Development are tasked with developing the mechanism to raise financing for these infrastructure projects. With all this background, I now start the session with first asking question from Mr. Vikas Sinha. Mr. Sinha, tell us something about this dedicated freight corridor project. What is the status of the project? And since it's a dedicated freight corridor, how this will bring change in the freight movement by railway network?
So good afternoon, everyone, and thank you for the opportunity to be interacting with this group. In as far as the dedicated freight corridor is concerned, it's slightly different from the context that you've already provided. So it's not a funded project. Equity participation is nil. So it's entirely funded by the multilateral institutions, that is JICA and the World Bank. Just to briefly touch on an aspect, or perhaps let me just tell you about the dedicated freight corridor, and then I can come back to a little digression. The dedicated freight corridor idea is very simple. Like we travel on a road, and I may be having a very powerful and efficient car, but if there is a auto rickshaw in front of me, I get stuck. So it's of mixed traffic. So the Indian Railways, 18% of our network carries 58% of the passenger traffic and 52% of the freight traffic. And obviously there's a lot of congestion. And the solution therefore being found is to set up a dedicated freight corridor. So the freight will come on our railway tracks, and the Indian Railway present network will be made available for the passenger networks. The idea is to reduce logistics costs in the country. Currently, there are the logistics cost of the logistics cost is about 9% of the GDP. After a lot of accompanying projects having been completed, Sagar Mala being one of them, Golden Quadrilateral being the other, dedicated freight corridor again being a part of that. The idea is to reduce this to about 7% of the GDP, and the world standard on that is about 4 to 5% of GDP. So that's the intention, and as far as our project is concerned, we expect to be able to deliver most of the project by June 23, except a small portion on the western sector, which is going to take about another 6 months. The projects are on EPC basis. So we have some very exceptionally large contracts. They have very modern contractual features, and in reference to the discussion today on disputes, even the dispute mechanism is one which is relatively advanced. And on the earlier discussion, we had the apprehension that the DRB process doesn't work. On my organization, we are one of the few organizations which actually implement the DRB decisions along the lines about the which are in operation with respect to the arbitration agreements, arbitration awards being challenged only after 75% is paid up to the contractor. In terms of the digression, so the dispute clause is something which has been incorporated within our own contract, largely as a feedback which has come through the multilateral institutions. And Abhimeet was mentioning about the clause on the land, where 90% of the land has to be made available. So these are again by way of responding to experience as to why certain contracts have not performed in the past. So that's the short introduction on dedicated freight corridor along with its contract clauses.
Linked to this is the question about the kind of contract you just said. It's a FIDIC-based contract. I understand that for the first time, DFCCIL has gone in India with the design-build lump-sum contract. So can you explain something about its feature and any difference it has with the EPC contract?
Not really. So to that extent, we have tried to reduce the risk for the contractor in not adopting an especially curated contractual condition. It's very much like the standard EPC contracts, and since a lot of you are do appear to me to be from the field which deals with infrastructure contracts, to that extent, it represents an advancement over what the typical EPC contracts are available on the government sector today. So there's a greater evening out of the risks between the employer and the contractor. And a lot of rights which would not accrue to the contractor under the standard EPC terms are available under the FIDIC terms. And to that extent, I say that the EPC contract terms on our contract being based on FIDIC offer a greater, as I expressed myself before, evening out of the risks. So that's the advantage that we have on account of using a form which is not driven by the government. So the accusation was that we often use contract forms which are written by us. So it's a single one-sided contract. So these are the mechanisms by which the industry is able to have a more even-handed contract put in place. And frankly, in the government, there is no preconceived notion that we must have clauses which are government friendly or industry, anti-industry. No, that's not our intention, because ultimately the idea is that the project has to be delivered, the contract has to succeed. And so to that extent, I would say it that DFC does have better EPC contracts than is otherwise prevalent on the government system.
Thank you. Now, Harsh, Mr. Sinha just said about the project being funded by the DFCCR being funded by multilateral agencies like JICA and World Bank. You have prior experience in handling complex project finance structures, funding related to them. Can you explain some of the complexities which you experienced in the debt financing side?
Sure, no, thanks. Very interesting conversations, and thanks for inviting me. So I'll actually say this more from the perspective of commercial financing, which is more for a project which is being developed by a private developer, because
yes.
that's where things get even more complicated. So, any infrastructure financing, the way I look at is, how are you allocating the risk, and B, if someone is taking that risk, then do you have enforceability around it? And when we do infra financing, I think the first and the biggest issue which used to come is the demand risk. And demand risk, who's taking? Is it the government taking demand risk, or is it being taken by the developer? And if it is indeed being taken by the developer, then the things become even more interesting, because at the end of the day, what is the kind of assessment you have done, and how much of economic growth, etc., can you project? And that's where, frankly, I've seen many projects actually not succeeding, where the demand assessment were not so great. The second is more on the cost overrun and time overrun, and which is another big area, and that's where I frankly feel that a greenfield project financing is completely different from a brownfield, like an operating project financing. And I think we should discuss that, because that has an important implication in terms of how the financing should work for infrastructure. How can you get large amount of financing for infrastructure in the country? So that is a big issue in terms of cost overrun and time overrun, and especially on cost overrun, you will have undertaking from the private sector developer that if a project goes under cost overrun, then he will finance. But ultimately, enforceability of it is not that easy, and we have seen several issues around those. The third aspect, which is very interesting, and it is a very unique issue in projects in India, is around the termination payments. So what happens, and with all right intention, and there is a sir from NHAI also, the award agency would actually define a project cost, and based on that project cost, all the termination payments would be linked. Now, ultimately, the loan which is being given to the project may be on a very different project cost, which typically would be much higher than what is in the project document. Now, if the project gets terminated during operations, then typically you will get 90% of the project cost, anything like that. But that project cost is a defined term. And that's where a big risk emerges for the lender, because you really don't have any recourse for the remaining amount, because the project cost which you finance is a much higher amount. And that, frankly, we saw was a big issue. I used to be in a multilateral at that time, and that actually prevented us from financing a large part of road program in India at that point of time. So, if I summarize, one is that how do you see the future? The second is how can you ring fence the operator in the project?
Yes,
and third is, in case of dispute, how is the lender's right protected? Because, still I feel that is the least focused area, that, how do you protect the lender if there is a dispute? Can lender come into the project easily? And how easily can they, how easily can they get payment for? Those are the issues I would say be more critical.
Akshay, we discussed the issue in the greenfield projects. Now, some of the brownfield projects Kotak Infrastructure Fund has invested in, and we note that at least 5-6 operating road assets have been acquired by Kotak Infrastructure Fund. So can you just discuss in brief about how this whole acquisition came about, about your infrastructure fund, and how different it is from alternate investment fund?
Sure, thank you. So we are an infrastructure fund incorporated in Singapore, and primarily equity based. And the objective was, of course, to invest across different life cycle stages of an infrastructure project. To Abhimeet's point on we acquiring road projects, there was a situation where the current owner of those roads was under some form of a liquidity stress. So he was looking at selling his operating roads at a good value so that he could use the proceeds to solve problems at his EPC business, and which of course we have seen in infra. It's a very common problem with a lot of EPC companies as well as project owners. So being an infra fund with the ability and the mandate to underwrite operating projects, we were able to step in along with our consortium investor members to do 100% acquisition of an operating project. And in this manner, we not only refinanced the debt, we also paid the equity, and the seller was able to recycle that equity to solve his issue. Of course, like us, there are a lot of other funds and different investment structures which are trying to replicate the strategy of acquiring operating infrastructure assets so that the capital can get recycled across the system, not just private sector developers, but also Indian banks who have lent to these projects. Abhimeet, you have the second point on AIFs?
Yeah.
Right. So AIFs, let me give a background. As I said, our first infra fund was incorporated in Singapore. There were two main reasons for that. At that time, the tax structure favored foreign investors to come in through a pooling vehicle outside India. Things have changed now because the government has made modifications to the tax code. So a non-resident investor will still be subject to payment of capital gains tax, whether the pooling vehicle is outside India or within India. Second thing, at that time when we set up the fund was foreign investors would get more comfort if the legal jurisdiction is outside India for example, Singapore, in case of any dispute, the idea was that it's easier to get any remedy. And again, in the last few years, the legal framework via AIFs has improved so much that we as asset managers have been able to convince a large part of our non-resident investors to let us set up the pooling vehicle within India. And that the credit goes to SEBI for having that AIF framework in place, which has given not just regulatory comfort, but also in terms of governance, and of course to the finance ministry to have the tax pass-through status incorporated in AIFs that is allowing us to tap into the international pool of capital. Because overall, considering the capital requirement and the availability with the government and the Indian private sector, there is a need to get the foreign capital in place, and AIF is a great vehicle to at least capture some part of the foreign money.
Okay. Akshay, just Harsh, over to you now. Akshay just spoke about AIFs, which is also a means of investing in operating assets. There's another thing is the bonds. So there's so much traction in the government bond segment, but not so much in the private corporate bond market. Any specific region you can speak about what has really led to not this corporate bond market not growing as per the demand?
So, actually, there are actually a couple of reasons, and let's take the demand side reason first, which is what you said. If you see the current environment in the debt market, I don't know how many of you actually work in the debt market, but if you talk to any of your brokers, you'll realize it's a very, how should I say, it's in some sort of monopolized kind of market. And that's why it's very hard for individual investors to access it easily. And as I say, a lot of democratization of this market needs to happen. Thankfully, that is now happening with some bond platforms which have come, and SEBI has just released a paper in terms of regulating these bond platforms. I think once you have that democratization, a lot of the demand will actually come. And the reason I say it, there was some statistics that, a number of FDs which all of us have in banks is humongous. And what are we paying? I mean, what are we getting? We are getting less than 5%, which is after taxes, not even paying inflation. So all of us want access to a good instrument which actually pays us more on our savings. So there is a lot of demand. It's the point, how do we access it? And that's hopefully in the next few years, we'll see it getting solved. The other issue is on the supply side, and which is where things get very interesting. That, on the corporate bond side, unfortunately, there have been, because of, credit rating frameworks not being proper and not being enough supply of the paper itself. The point Akshay made in terms of operating projects now being taken over by AIFs and all, there is a decent amount of supply of the paper which will come. Because ultimately, as a bond investor, we will only invest in operating projects which have some operating history. Based on it, we'll get a credit rating which will be higher than investment grade at least. So I think those things need to be put in place. As I see, in the next couple of years, you will see that happening. Already, of course, in the offshore market, a lot of the infrastructure companies are raising bonds. So in domestic market, we'll see things improving.
Yeah, some of the regions could be like strict regulatory framework of IRDAI, Pension Fund Regulatory Authority, and obviously the operating road assets or such assets being the ranking of credit rating of the same being low. That's why the bond financing is impacted.
That's right. No, that is a very good point. But, the other, so we used to speak to a lot of these agencies also, PFRDA and all. And frankly, in some sense, they are also open to changing this based on the supply of the paper. They also want to see that high quality paper. And if they see that high quality paper, things will change. But as of now, that is, of course, a constraint.
Mr. Sinha, initially you discussed about the provision with respect to handling of disputes. That was a brief summation of that. Can you explain in detail what provisions you really include in your contract, and has there been any enforcement issue with respect to the contract?
Oh yes, so there have been a lot of enforcement issues, and Shishir is here, so he is aware of some of the disputes, and I am afraid I don't recollect the name, but again, one of our contractors is here. So well, there are enforcement issues, but as I always say, these issues can be solved. Now, one of the initiatives which has already been stated by the Government of India way back in 2016 is with respect to how do you deal with the arbitration awards. Currently, the government has 90,000 crores of arbitration awards which have not been paid to the persons who won the arbitration. So on DFCCIL, we accept the Government of India directive in that regard. And if we are to challenge any arbitration awards, the Government of India policy of paying 75% against a BG is something that we follow. And in respect of the pre-arbitration awards, again, we have on our own initiative implemented a similar policy. In as far as the structure is concerned, again, it's a very well-known structure. There is a pre-arbitration provision. There's an occasion for settlement of the dispute between the parties, and subsequently, of course, arbitration and other legal causes. In as far as settlement is concerned, our organization is yet to formally accept the settlement rules, but we are in a very advanced stage of incorporating some of the best practices which are already in operation in a large number of PSUs. So there will be disputes, we acknowledge that, and we try our best to have that resolved in a manner which is least disruptive of business. So for instance, in the DAB provision, the pre-arbitration provision we have, the limitation is of 84 days. And our experience is that none of those disputes could get completed. Perhaps only the exceptional one could be completed within that period of 84 days. So now, my organization is trying to experiment with a policy that if you don't complete it by 84 days, then those DAB members are going to suffer a decline in their fees. So these are methods by which we want to bring about an efficient enforcement mechanism. And again, a very simple thing which everybody used during COVID was with respect to how do you do your proceedings online? And we intend to again make that online as a compulsory part of our dispute resolution process. So really speaking, perhaps the question as to whether there are enforcement issues should be put out to our contractors. I have a good picture to paint of myself, but I think the vote is out there.
Okay, thank you. Well, Akshay, we just spoke about the IFs, and now one of the latest things is InvITs. So InvITs are allowed in the under construction projects also, private InvITs, and the public InvITs are like, so similar to InvITs, can AIFs be also used in under construction projects?
Yes, AIFs can be used, and there are of course different types of AIFs, category 1, category 2, category 3, and there is no per se sector restriction unless it is part of the specified category 1 project. And again, AIFs can be used for operating as well as under construction projects. But I think for operating projects, right now InvIT is the real mechanism through which the investment can take place.
Okay. Harsh,
we have read something about green bonds. So can you explain something about what are these green bonds? Even I think there are SEBI regulations in respect to same also.
So, green bond is, as a layman, I would say, is money raised for purposes of investing in green economy. Now, what does green economy mean? Green economy, and that's frankly the biggest question right now in India, because India doesn't have a taxonomy, which is kind of the standards used to determine whether a project is green or not. And as we speak, I understand those discussions are going, are underway in the finance ministry, and we'll soon have a taxonomy. But internationally, typically when you raise money to invest in a renewable energy project, would typically be classified as a green bond. Now, why should I do a green bond? I think that should be the logical question. So for an issuer, I think a green bond comes with a certain advantages, because what is essentially happening, if you see, is a lot of the institutional money, I mean, if you take the global pool of capital, it's almost $100 trillion, out of which institutional capital is close to $40 trillion. And if I just take the amount of capital, I mean, in terms of institutions who have taken zero carbon pledges, what does a zero carbon pledge mean? That any new investment I make will not be in a carbon emitting asset. So that 40 trillion, roughly 2/3 of the capital has already taken a zero carbon pledge. So what we are essentially saying, out of $40 trillion of institutional investment available in the global world, 30 trillion has some sort of a zero carbon pledge. Now those guys are only going to invest in green financing. And that's why raising green bonds is important. If you have a project which can classify as a green economy project, then you can have access to that capital. I'm refraining from saying that those are cheap bonds and all, because that's generally the perception, but typically my experience has been there are some, you can actually find data pointing to both the cases. It's more about getting the right capital, I would say.
Okay. Thanks. Mr. Sinha, one last question for you. About that contract model which DFCCIL uses, design build contract. In your view, in what kind of other projects this kind of contract can be used?
Well, the contract form is already being used in most of the infrastructure projects, maybe by some other name.
Okay.
We are one of the few organizations today which can claim to be operating a FIDIC contract. Most of the infrastructure projects are being done under various contract forms designed by the awarding agency itself. Now, frankly, there are all sorts of contracts and all sorts of experience, and therefore I will not state that one form is relatively more successful or one form has certain advantages compared to other. But certainly this is a very good model to follow. And the popularity of this model being in place for a large number of infrastructure projects which are already under operation is a proof of it working. So if one were to do a sample survey even of this room, we would come across this design build form being used in a large number of infrastructure projects. Of course, there would be situations where perhaps a EPC contract or perhaps a BOQ contract would be better. But the flexibility of the design build contract is immense, and it offers a very happy marriage of risks. So an EPC contract is more designed to a situation where perhaps the awarding agency itself is not aware of the risks. And BOQ is one where the awarding agency is very well aware of the risks. And to that extent, the design build contract occupies the space whereby the expertise is shared between the parties. Okay. And therefore, the potential for this contract form to be used in infrastructure projects of all sorts of sizes and contract deliverables is immense.
Akshay, the national monetization pipeline, like government will monetize the brownfield assets. So how you look forward to that, and any suggestion for apart from InvITs and the bonds and such new things for financing structure, any new structures you are think which we can include in India?
So national monetization plan is of course extremely ambitious, but in terms of what will move the needle is that if they have retail bond participation and if the InvIT continues to develop, I think it will be a fantastic outcome. The reason is, let me talk about the InvIT because of its importance here. Because the risk allocation is done properly in an InvIT, it has the potential to possibly be the single largest source of monetization for the core infra part of the national monetization plan of the government. An InvIT today is giving comfort to investors because as per law, 90% of your surplus you need to distribute. For certain types of InvITs, you have to invest mostly in operating projects. So what is happening is that international investors who globally consider infrastructure to be a relatively stable and safe asset class, when they look at India, as Harsh said, the construction risk is significantly higher as compared to operating risk in India vis-a-vis the gap or the premium in other countries. So therefore, the international capital that we meet, they are quite open to get an exposure only to the operating asset class, which is what InvIT does in an extremely smooth manner where the manager is in India. Along with that, of course, there are tax benefits. For a non-resident, depending on the type of InvIT, dividends could be free, capital gains could be zero, and for interest income, the withholding tax could be as low as 5%, and plus such will be some 5.46. Already there are more than 15 InvITs. In fact, beyond the core infra, there is a talk about an InvIT in the school sector. The InvITs have already been launched, they are public as well as private. And together, if this pool is allowed to grow, I think in terms of impact on NMP, Abhimeet, it is InvIT which will actually create the biggest benefit.
Okay, thank you. Harsh, about this National Infrastructure Bank for financing infrastructure and development, one of the objective is development of the bond market. You spoke about in detail about the bond financing. So can you look forward with an institution like this, a big institution like this, having such an objective, we can really see the bond market flourishing?
So, actually, I would divide your question into two parts, and I'll answer the core part of your question later. But, I actually want everyone to think of 30 years ago. At that time, India had actually two special infrastructure financing institutions called ICICI and IDBI. And both of those institutions actually became a bank, a commercial bank. Then we also had an institution called IDFC, which also decided to become a bank. So as before these institutions, actually we didn't have a specialized infrastructure financing entity in the country. So there was a huge need for it, and I'm glad government is thinking of it. Hopefully it will help in getting the the greenfield part of the equation broken, because like Akshay was saying, there is a lot of capital which is available on the operating part. The issue is actually getting capital for the greenfield projects, and that's hopefully the objective which this institution solves. Now coming to your point on the bond market, and that's why I wanted to remind everyone that what had happened in the past. Those institutions were great institutions. They had great underwriting skills for infrastructure. Unfortunately, the challenge for those institutions was for being able to access a large part of the capital market. And one of the big reasons for that was the bond market was not as evolved at that point of time. So I don't know the right solution, but hopefully if this institution builds credibility and they are able to find the right solutions in terms of splitting the greenfield versus brownfield and raise long-term financing through bond market, I think we can have a win-win situation, both on the infrastructure development as well as of development of the bond market in India, because this agency can be that intermediary which allows comfort for the bond investors as well. So really looking forward to it.
Okay.
By the way, Harsh, FPIs have been allowed to invest in InvIT as debt. So the hope is that the InvIT through the debt issuance can also contribute to development of the bond market.
That's very good.
That's very good. I think we have had a fruitful discussion with my panelists contributing the knowledge which we look forward to. And now I open the floor for questions, if any, on the issue we discussed right now.
Mr. Sinha mentioned about successful instances of dispute resolution using dispute resolution board in your organization. Ministry of Statistics and Program Implementation has come up with a report studying about 1,500 projects, out of which more than 400 projects are, 600 projects are delayed, and in more than 400 projects, there is cost overruns to the tune of 4.73 lakh crore rupees. All this, so out of 1,500 projects under study, more than 1,000 projects, that's 2/3 of the projects, will go for arbitration. In London, they have a specialized technology and construction court, TCC court. After successful implementation of adjudication, most of the cases that come up in TCC court is for enforcement of DB award, and very less qua arbitration. So for all these 1,500 or rather 1,000 projects which will go for arbitration, how should DB or dispute resolution board mechanism should be successful implementation, so there is a speedy and economical resolution of disputes?
So thank you for your question. From the background of that question, there is perhaps the concern on the enforcement part. And as far as the DAB process itself is concerned, I would reckon that you find that process to be of a particular efficiency, which is not so much of a concern as the enforcement part. So with that understanding, I don't know, I'm not a lawyer, and therefore I can't comment on the attitude with respect to implementation of commercial awards. The government has already made those commercial courts, and therefore these initiatives are being made to bring about an environment whereby the business aspect of a dispute begins to get attention. So for instance, I'm an employer, I give out a project and somebody takes that, and there is a dispute, and that gets decided 7 years later. Then at that point of that adjudication, certainly I'm not going to be available on taking the advantages of that adjudication. Perhaps even the developer could have changed hands. So what happens is nobody is invested in that decision. So the way to increase the enforceability of a DAB award, I am afraid I don't have the IQ to answer that. But certainly a step like a partial implementation of the sort that we have done on our organization. So you pay 75% of the DAB award to the party before you invoke an invitation, before you invoke the arbitration. So what happens is that enforcement part is addressed to a very large extent. And I wonder if anybody has paid attention to the mathematics of the Delhi Metro award. See, the initial award is only 2873 crores. So I may be a couple of crores here and there. And how much does Delhi Metro have to pay now? 6,300 crores. So where is that additional 3,500 crores coming from? It is coming from what lawyers call pendulite interest. And what is that a reflection of? The enforcement inefficiency. And therefore, the enforcement inefficiency is something that all of us who are having something to do with projects need to be paying attention towards. And the development of a commercial court is a very welcome initiative. Apart from what the government does, it is also open to institutions like us to take steps to improve enforcement of the DAP awards. Thank you.
Any more question? So we all are hungry now, we should know.
Sir, even I belong to a public sector project where our contracts also go undergo this DRB process. Now, generally, it is observed that parties dilly-dally in the aspects of appointment of DRB members only, right? So sometimes they are not accepting the members and all those things. So what would you suggest? We can have a larger panel kind of thing for successful DRB implementation process.
Okay, I just thought perhaps I stopped you, so yeah.
No,
So,
I'm done, sir.
Okay, thank you. So on a lot of contractual issues, there would be indecisive elements. And the way we have resolved that part on our contract is that in the case of in case of a disagreement between the parties as to the nomination of a DAB member, after a particular time, which I think is around like 128 days, the nomination will be done by the chairperson of the Institution of Engineers. So then what happens is the decision-making process gets out of the hand of the parties and goes to a neutral party. And this is only one of the examples whereby difficulties of this sort can be resolved by taking out the intransigence in the issue and placing it in the hands of a neutral person or a neutral situation. Thank you.